case briefs, and so much more. LSData's got what you're looking for.
The scene for the 1991 case, Levine v. Smith in the Delaware Supreme Court, was set when disputes arose surrounding a shareholder derivative suit. Central to these was the principle of a board of directors making decisions on behalf of the company, with a standing presumption that such decisions are in the company's best interest. This can only be overturned on presentation of valid evidence demonstrating an unreasonable action or a divergent from the company's foremost interest. In this case, the bone of contention revolved around two legal issues. First off was the failure of the plaintiffs to sufficiently outline a claim of demand futility due to a meager provision of specific facts. Secondly, the extent of the court's discretion in granting relief from judgment held sway. Applying the traditional business judgment rule, it decided to review the board's decision. A spark of hope flickered for the plaintiffs when the court accorded them the chance to file a new complaint, albeit largely relying on newly discovered evidence. Consequently, the Court of Chancery explored the restated claim of demand futility and discovered that it still fell short, lacking specific facts to instill doubt about the independence of a majority of the GM board. The baton was then passed to the Delaware Supreme Court. Confirmation came down that the reasonable doubt pleading standard would apply to a claim of wrongful refusal of demand. Levine, a shareholder plaintiff, felt slighted by the decision to deny him limited discovery to back his claim and consequently raised an appeal. Sad for Levine, it emerged that the court found his amended complaint insufficient. Thus, it couldn't manage to topple the firmly established business judgment rule presumption. The tables turned back to the plaintiffs. They found themselves immersed in the deep end of failure in stating a demand futility claim under Rule 23.1. The court stood its ground, affirming the trial court's prerogative in granting Rule 60(b) relief and putting limits on new complaints. The judgment would hence be put under the magnifier lens of the business judgment rule, a move placing the burden of proof squarely on the challenging party.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.